So, you probably know the copyright basics. Don't pirate movies, don't download illegal torrents or cracked video games, don't grab images off Google for your school newspaper without permission, don't repost someone's TikTok without credit, that kind of thing. I've covered the basics of copyright in another video. Hi, I'm Professor Mark Grabowski, and in this video I want to focus on the copyright issues that actually affect your daily life online. Every time you post a video with background music, share a meme, or use a clip in a school project, you're navigating copyright law. The copyright battles happening right now over AI, platform liability, and fair use are going to shape what tools you have access to and how you can make a living in creative and technical fields. Let's start with something you use constantly: YouTube, TikTok, Instagram. Have you ever wondered how these platforms can exist when millions of people upload copyrighted content every day? YouTube gets over 500 hours of video uploaded every single minute. There's no way they could have lawyers reviewing all of that. The answer is a 1998 U.S. law known as Digital Millennium Copyright Act's safe harbor provision. Basically, platforms aren't liable for what users post, but only if they follow specific rules. They need to take down content quickly when copyright owners complain, let users dispute those takedowns, and register an agent with the Copyright Office. Quick clarification: the DMCA safe harbor is specifically about copyright infringement. There's a different law, Section 230, which I cover in another video, that protects platforms from liability for other illegal content users post, like defamation or harassment. DMCA shields copyright infringement. Section 230 shields everything else. Without this protection, these platforms couldn't exist. If YouTube had to have a human lawyer review every single video before it went up, with 500 hours worth of video being uploaded every minute, it would be economically impossible. User-generated content platforms, as we know them, depend on this legal framework. This is why YouTube has a feature called Content ID, which is a system that detects copyrighted music and either blocks your video or demonetizes it. YouTube isn't being difficult. Instead, they're covering their legal obligations to avoid being sued. Now you might wonder why you can use a certain popular song on TikTok, but not on YouTube. That's because platforms like TikTok and Instagram have negotiated licensing agreements with music labels and publishers. These agreements allow users to include specific songs in their videos on those platforms. But that license only applies on that specific platform. If you download your TikTok and repost it on YouTube, you're no longer covered by TikTok's license, which is why YouTube might flag or mute the audio. Now, the DMCA system isn't perfect and sometimes even gets exploited. Sometimes copyright holders file false takedown notices to silence critics or competitors. For example, if you post a negative review, suddenly you might find that your video has been taken down for quote-unquote copyright violation, even though it's not really a copyright violation. You can file a counter notification, but that takes weeks, and by then the conversation has moved on. It's a real problem for free speech. Now let's talk about something that's shaped our digital world: whether technology companies are responsible when people use their products to infringe copyright. In 1984, movie studios sued the tech company Sony over its VCRs, which were those ancient devices that let you record TV shows onto tapes and play them back later. The studios claimed VCRs were illegal because people could record copyrighted movies and share them with others. But the U.S. Supreme Court said no. They ruled that VCRs have substantial non-infringing uses because people often use it to record TV shows for personal viewing or to copy homemade videos, which are perfectly legal activities. So just because a technology can be used for infringement doesn't make the company liable. This is significant. This same principle is why BitTorrent exists, why screen recording software is legal, and why 3D printers aren't banned even though you could print copyrighted designs. But there's a line. If you create a technology that exists primarily or solely to help people infringe copyright, you can be liable for contributory infringement. This is what killed Napster in 2001. Its main purpose was letting people share copyrighted music without permission. The same thing happened with LimeWire and Mega Upload. Here's something that may surprise you. When you buy digital products, such as software, games, and movies, you don't actually own them. Instead, you're licensing them. And buried in those terms of service you never read are restrictions on what you can do. There's a legal concept called reverse engineering, which is taking something apart to figure out how it works. Under certain conditions, this is legal and protected. It's how people create compatible products and add new features to existing software. But most companies shut this down through their terms of service. There was a case involving World of Warcraft where fans reverse engineered the game to create their own server. The Copyright Act actually allows reverse engineering for interoperability, but the court ruled that users had waived that right by agreeing to the game's terms of service. This issue can also affect us in unexpected ways. For example, farm equipment manufacturers use copyright and patent law to claim that only their authorized technicians can repair tractors because the software in those tractors is copyrighted. But many customers think this is ridiculous, and some states have started passing right-to-repair laws to address this. Now, you might be thinking, what about fair use? Isn't there an exception to copyright law that allows you to use copyrighted material for things like education, commentary, or news? Yes, there is. And fair use is incredibly important. It's what allows journalists to quote sources, teachers to use excerpts from readings in class, critics to show clips when reviewing movies, and students to cite research in their papers. Fair use is the main legal protection that keeps copyright from completely shutting down commentary, criticism, and creativity. But fair use is probably the most misunderstood part of copyright law. First, let me address some myths. You've probably heard you can use 30 seconds of a song or 10% of a work without permission. But that's completely wrong. There's no magic number or percentage. And saying no copyright infringement intended or all copyright to the owner in your video description does absolutely nothing legally. It's like writing I don't consent to speeding tickets on your car. It has zero legal effect. So how do you know if something qualifies for fair use? Well, fair use is evaluated case by case using 4 factors. The first factor is the purpose and character. Are you commenting, criticizing, teaching, or transforming the work into something new? If so, that helps. But if you're just reposting because it's popular or using it commercially, well, that hurts. For students, classwork is generally non-commercial, but freelance work for pay isn't. The second factor to determine whether something qualifies for fair use is the nature of the work. Factual material like news footage is treated more favorably than highly creative works like songs or artwork. The third factor is the amount used. It's not just how much you copy, but whether you took the heart of the work. A news magazine once lost a lawsuit using just 300 words from a 500-page book because those 300 words were the most important part and cost the publisher a licensing deal. The fourth and final factor is market impact. This is often the most important factor. Does your use substitute for the original or cost the owner potential sales or licensing deals? Now let's apply that test, and I'll give you some examples of things that can generally claim fair use. YouTube video essays analyzing films and clips, news articles quoting tweets, professors sharing textbook excerpts for class, and book reviews with short passages. And here are some examples of copying that probably doesn't qualify for fair use. Posting full songs with lyrics, using popular music as a vlog background, or reposting entire artworks, even with credit. The bottom line is, fair use is real, but it's unpredictable and decided case by case. So when in doubt, get permission or use licensed material. The most interesting fair use situations involve transformative works, which is when you take copyrighted material and create something with an entirely new expression, meaning, or message. The Supreme Court addressed this in 1994 when Two Live Crew made a parody of a popular classic rock and roll song, Oh Pretty Woman. The rappers used the same tune, but completely changed the meaning to comment on the original. The court ruled that's transformative fair use. More recently, Google won a significant case against Oracle over using Java code in Android. Even though Google copied substantial portions, the court said they transformed it by creating entirely new smartphone functionality. Parody gets special treatment in fair use because to parody something, you have to use enough of it so people recognize what you're making fun of. But here's the key. You have to actually be commenting or criticizing the original work itself. If you change Taylor Swift lyrics to make fun of Taylor Swift or her music, that's probably fair use. But if you just change her lyrics to talk about your sorority drama and post it on YouTube, even if it's funny, that's probably not fair use. You're not parodying Taylor Swift. You're just borrowing her tune as a convenient vehicle for your own message. Saturday Night Live successfully uses parody because they're obviously commenting on and criticizing the originals. They only use what's necessary to evoke the original, and they're not market substitutes for the original works. Let's talk about something you probably do regularly: making and sharing memes. Legally speaking, most memes are copyright infringement. You're taking someone's copyrighted photo or artwork, adding text, and distributing it. That's technically creating an unauthorized derivative work. In practice, most copyright owners don't care. Some even appreciate it as free publicity. Take, for example, the well-known distracted boyfriend meme, which appears in my cyber law textbook. The photographer said he won't sue unless people use it in offensive or harmful ways. He's accepted that his image is everywhere, but some copyright owners are aggressive. Getty Images has pursued people for meme usage. When President Trump posted a Nickelback parody during his impeachment, the band got Twitter to remove it. The key thing to be aware of is that memes are especially risky if you're using them commercially, like in advertising. If you're concerned about legal risk, stick to images you created yourself or that are properly licensed. It's the same situation with fan fiction. Platforms like Wattpad host millions of stories using copyrighted characters from Harry Potter, Marvel, and so on. Most creators tolerate it as free marketing, but some don't. The late novelist Anne Rice was known to go after fan fiction writers through legal action. Finally, let's discuss the issue that's going to define copyright for future generations, which is artificial intelligence. Right now, significant lawsuits are happening over whether AI platforms like ChatGPT using copyrighted materials is fair use. Getty Images, book publishers, music labels, and visual artists are all suing AI companies. Their argument is that these companies scrape millions or even billions of copyrighted works without permission to train their models. AI companies argue it's transformative fair use because they're not reproducing the works. Instead, their LLMs are learning patterns to create new content. But copyright owners say it's mass theft that could destroy their markets. This isn't a hypothetical situation. Some companies are already avoiding litigation by making licensing deals, like Amazon, which made an agreement with the New York Times. How these cases are resolved will shape whether AI development happens or gets locked behind expensive licensing deals. And then there's the issue of whether an AI-generated work can receive copyright protection. So far, courts have ruled no. Only humans can apply for and receive copyright protection for their works. But that could change in the future. So in summary, copyright in the digital age is more complex than you might think. Platforms you rely on exist in a delicate legal balance. The devices and software you buy come with strings attached. Fair use is powerful, but unpredictable. Your creative expression online, such as memes, fanworks, and remixes, lives in legal gray areas that depend on who decides to enforce their rights. The key takeaways are this: be thoughtful about what you create and share. Understand that most of what happens online exists because copyright owners choose not to enforce their rights, not because it's clearly legal. And pay attention to how copyright cases unfold, because they're going to determine what tools you have access to and how you can use them for the rest of your careers. Well, this has been Professor Grabowski. Thanks for listening, and please don't make any mean memes about me.